For those of us who have kids, we're all very familiar with the experience of going to a trampoline park or a sky zone or even an amusement park and having to fill out one of those forms where we're waiving any claim we have against the facility, and they won't let you use it unless you sign the form. And while most people don't read it, that form always used to say the same thing, which is you are giving up your right to sue the facility even in the event that they were negligent and caused injury to you or your children. A lot of people were very upset about the fact that this rule existed, but for many, many years, that was the law in Maryland. If you signed this form and then the facility was negligent and that negligence did cause an injury, you were not able to sue them. You had given up that claim. A group of plaintiffs' lawyers here in Maryland, myself included, decided we didn't think that was right. And so we spent quite a while over the last few years really trying to get that law changed and get the Maryland legislature to get rid of this waiver provision. And so basically disallow facilities from being able to have you sign something that says, look, you don't get to sue us even if we're negligent. One of the big pushes that we made was to say, look, we're not asking for them to give up the ability to protect themselves from any and all claims. But what we are saying is that when you have a system where a facility, a sky zone or a trampoline park or one of these types of places, when you have a system where they're able to have you sign something that says, even if we're negligent, you're still not able to sue us, then what it does is it creates this reverse incentive for these facilities to not care about whether or not they're meeting their obligations to the children that use the facilities, our children. And as a result, you create a system where people are more likely to get hurt because the facilities have no incentive to ensure that people are safe, and that leads to more injuries. That argument proved to be very persuasive, and as of October 1st, 2024, that is no longer the law in Maryland. The Maryland legislature passed a revision that now says that those facilities, amusement parks, sky zones, jump zones, trampoline parks, are no longer allowed to have people execute a waiver, to sign a waiver that says that even if they're negligent, you don't get to sue them. As of October the 1st, 2024, you are now allowed to sue these facilities if they are negligent in the operation of the facilities and that negligence causes injury to you or your loved ones. It's important to distinguish between the types of claims that you may have against one of these facilities and exactly what this law does. So even with this law taking effect, you are not allowed, for example, if your kid's running down one of the pathways at Sky Zone or Jump Zone and they fall and they hurt themselves, you would not be able to pursue a claim for that. That's always been the law, because in that situation, they won't have done anything negligent to have caused the injury. But if one of their employees is supposed to be supervising a piece of equipment and fails to do so, if one of their pieces of equipment isn't working the way that it's supposed to and they haven't taken the time to fix it, prior to October the 1st, 2024, if somebody was injured as a result of that failure, you still were not able to sue them if you signed a waiver. That specifically is what has changed. You still aren't able to pursue claims against them when they did nothing wrong. But now, if they made a mistake that led to injury, for the first time, you are able to pursue that claim against them. And if you have such a claim, you should contact Dubo Law and we can help you.